agency will decide.
Yeah. Well, I don't think there's any issues. It's not past consideration.
If he says, if His Excellency says yes, we'll just remove the banners outside.
Okay.
So today, just to clarify, you'll be the defendant.
Sorry?
You'll be the defendant for today's hearing.
Because
they're claiming.
I'm the claimant.
Yeah.
And he is the
Second defendant.
second defendant.
Second defendant.
Yes.
Okay. Just clarify. That's why it confuses me a lot.
Yeah.
I have 2 minutes. 1 minute. Yeah, everything's pretty. If you want, you can. It's actually very thorough, the speaking process. So the mic is right there. You don't have to talk into it, but it's quite thorough. Okay. Thank you. Can you bring me one more, please? Council ready? Council ready?
I'm sorry?
Council ready?
Yes, thank you.
Yes.
Sorry. That's what I mean.
Perhaps against this hiring decision on traffic
Your Honor, today we have a hearing in the matter of CFI 011-2018, Tatiana Mikhailovna Akhmedova versus Farhad Temur Ogli Akhmedov. The claimant is represented by Michael Black QC, assisted by Andrew Holden, by Fifth & Co., and the defendant is represented by Vernon Flynn QC, assisted by Sharif Shivji, represented by Al-Tamimi Law Firm.
Thank you, Hajo. I guess I'm hearing some kind of echo in the recording. Is that normal, or Hajo, are we okay with that? Is there an echo or something?
There's an echo, yeah. I'll send a message to adjust.
Okay. Good morning, everyone.
Good morning, Your Honor.
Yes. We're here on the return date
Yes.
Unless the claimant wants to, sorry, the second respondent wants to call it the first return date. I would rather call it return date. Yes, we are dealing with the jurisdictional challenge that's raised by you, but before I allow you to go with your application or challenge, I would like to address some of housekeeping points. Well, first of all, I've read both parties' submissions, and I've gone also through some of the authorities as well, not all of it. Yeah, I would urge the second respondent to start with responding to the claimant point that there is no evidence filed by Al-Tamimi before we go on with the jurisdictional challenge.
Yes.
And then I would like maybe to hear from you what kind of tactic you're taking through this proceeding, like the matter of whether return date, another return date, and how you going to deal with this jurisdictional challenge without putting any evidence, at least dealing with the relation between the first and second defendant. Yeah, and then I think to your secondary defense and the challenge of jurisdictional challenge, that the claimant failed to address the court with the right, maybe, and the right law or precedent.
Yes.
Well, I think my first impression is that, I mean, unless your challenge, I mean, succeeded, that point again would fail. Unless you really show me this is the right way, this is the law that should be applicable, which would stop this court dealing with the matter, then I think the secondary point would be. So I would invite you not to take long time addressing that secondary point, because I believe they are aware and they are very contacted.
Yes.
Yeah, you may start.
Thank
you.
you.
We'll hear from Mr. Black. And if you're ready, if you're ready to address even any other point that you have just seen in the claimant skeleton argument, you might have one go. I mean, instead of second go, you might finish up everything you want. Then we turn to Mr. Black.
Yes.
Yes, go ahead.
So Your Honour, Your Excellency, there's just one other housekeeping matter before, not to interrupt my friend. I just noticed that outside there was a sign saying private hearing, and I think the bar has agreed, subject to Your Excellency's view, that this actually is a public hearing, which means that any judgment wouldn't have to be redacted or anything like that.
Oh, this is a public hearing. The first one was private, but
Yes.
there's the second one.
Yes.
I think yes. Yeah.
Thank you very much.
Yes, Your Honour, we're agreed about the public hearing.
You agree with that?
Yes.
But you like the sign anyway. Go ahead.
So, Your Honour, I'm very happy to address Your Honour's 3 points.
Right.
As you've ruled, this is in fact the return date for the wife's freezing order. Now, the important thing I should make clear at the outset is, what we have made clear is that we intend to challenge the order on the grounds of jurisdiction only. We are expressly not submitting to the jurisdiction of the court. And so this is not the inter partes hearing on the merits of the injunction, or indeed it's not our hearing of our application to challenge jurisdiction generally. If we hadn't issued an application at all, the position would be that it's for the claimant to persuade the court that the injunction should be continued. And so the position as it stands now is that we are simply challenging on jurisdiction. And that boils down to a very simple point. And that very simple point is that the court has no territorial jurisdiction over the second defendant. Now, we refer to it as territorial jurisdiction because it's referred to as such in the cases. The second defendant in the skeleton says, well, that's the wrong term. It should be statutory jurisdiction. And it's sometimes also called in the cases personal jurisdiction. But, Your Excellency, it doesn't matter what the label is. The point is that without such jurisdiction over the second defendant, this court can't grant a freezing order against the second defendant, or indeed any other order. So unless they can persuade Your Lordship that there is territorial or statutory or personal jurisdiction, or however you label it, then the court can't grant any orders at all. That's quite separate to our applications to challenge jurisdiction generally. And that is what they have to do. And
So you just said that if they convince me there is, I mean, what called statutory jurisdiction,
yes,
so that should be sufficient.
if they can show you that there is.
So you giving them the chance to go beyond the boundary of personal or territorial jurisdiction?
No, Your Honour. We call it territorial. And it's been referred to territorial in this.
I just hear you saying, unless they
Yes.
convince that there is a statutory jurisdiction,
Yes.
then the court cannot go.
Exactly.
So
It doesn't matter what the label is. The court,
so you have your own definition to the statutory jurisdiction.
No, I don't have my own I don't have my own definition.
Why?
I have the definition that is the DIFC law. They have to bring themselves within that law. Now, whether you call it territorial or personal or statutory doesn't matter what the label is. They must show Your Excellency that they have jurisdiction under the law. That is a fundamental point, and they haven't done that, and they can't do it against my client.
So you're saying the second defendant must come under one of these categories of jurisdiction?
Yes, it must.
Yeah.
And the only way in which they advance it is because they have a judgment against the husband in England. That's all they have. They don't advance it on any of the other grounds, just that ground. And that doesn't affect my client at all. So unless they can show Your Lordship, Your Excellency, that is the case, it doesn't get to first base. And it doesn't matter.
Are you challenging that point? Like, what's the claimant trying to raise? Defendant 1, defendant 2 are one and the same.
But they say that. They say that.
Are you saying this is not even my jurisdiction? To look at this link between the
Yes,
two
I
defendants?
I am.
Are you going? I haven't seen that. I mean,
Let me explain why.
expressly in your submission.
We say so expressly, very clearly. The only judgment that they have, and the only basis for the jurisdiction is the judgment. It's a judgment against the husband.
Well, I understand that. What I'm saying, they come to this court
Yes.
saying the first defendant and the second one are just the same. It's just mirror mask.
Yes. But
That's what they say.
Right.
Well, they want the court to treat this court, the party is the defendants,
Yes.
are one entity.
Well, the question for this court,
And they come up with evidence,
yes, they have a claim.
witness statement and
Yeah.
document as well,
But
trying to show that.
yes, but that is Your Excellency. That is a claim. It is. They don't have a judgment saying that. They claim they're one and the same, but there is a difference between having a judgment.
Yeah, but this is an interlocutory application, and this is trying to preserve the assets, and this is usually can happen before the proceedings start, the real claim starts.
Not unless there is jurisdiction. Not unless there is jurisdiction. You have to found the jurisdiction in the DIFC. If they don't found the jurisdiction, they can't bring a claim. They can't get any order. I'm not disputing the issue for the husband. They have a judgment against the husband. But they can't bring a judgment against the husband to this court and say you should treat that as a judgment against the second defendant. Because the judgment is not against the second defendant. It is only against the husband. So they don't have, there is no jurisdiction to bring the claim or make any interlocutory orders unless they have a statutory basis for bringing any claim against my client. And that is a very basic point. And it doesn't matter how broad what is called the substantive jurisdiction is. It doesn't matter that the court has very wide powers to grant freezing orders. We accept that the power of the court to grant a freezing order is broad, but it has to be exercised against a party who is subject to the jurisdiction of the court. Now that, in this case, is the husband. It is not the second defendant. And that is fundamental. It's absolutely basic. Unless they can do that, they can't have any orders against my client at all. And that is really very fundamental to the case. Now, you were asking about the terminology. And we got the skeleton last night. Now, in the cases, it's frequently referred to as territorial jurisdiction. And we say that that is in fact how it's referred to in the DIFC. And what we've looked at overnight is in fact two things to show, Your Excellency, which, if I may, I hand up. I sent them to my learned friend last night. I'll hand them all up. The first is a speech by the Chief Justice in Kuala Lumpur, Malaysia, on the 1st of November 2008. Do you have that?
This is a case.
There are two cases, one in English and one a DIFC case, and one which says at the top, the courts of the Dubai.
Yes, I see.
And you'll see, if you look just below the heading, the conference in Kuala Lumpur, the 1st of November 2008, by the now Chief Justice, Mr. Michael Kwan. And if you go, I'm afraid it's not paginated, but if you go to the 5th page,
Okay, with this.
and it says the court of first instance is a civil or Sharia court. Did you see that?
Wait, let me a second. The 5th, yes. What paragraph you referring to?
There's the second one down, which is in large blue type. The court of first instance. Yes.
Okay, because I just saw my name on the second paragraph. Anyway.
Well, I can understand why you were diverted. But if you turn to the 5th page,
yes,
it's a very short passage. The court of first instance is a civil or Sharia court. Do you see that?
Yep.
With jurisdiction over all actions and matters, except where this is any other law has granted exclusive jurisdiction to a special tribunal or judicial committee. And then it says, Article 5 of the Dubai Law number 12 of 2004 serves the purpose of both circumscribing subject matter jurisdiction, personal and territorial jurisdiction. In other words, what the Chief Justice is saying is that you look to Article 5 to see the jurisdiction of the court, and he refers to it as subject matter, personal and territorial. It is likely to be the determinative clause where the jurisdiction of the court is concerned. The court cannot have personal jurisdiction over any defendant not falling under its subject matter jurisdiction. Important for two reasons. One is the reference to territorial jurisdiction. It doesn't, as I say, it doesn't matter what you call it, but you look in this court to Article 5 of the Dubai Law to work out whether or not the court has jurisdiction. And if it doesn't fall within the provisions of the law, the court doesn't have jurisdiction. And we've also given you the Peter Gray case, just really to show Your Excellency that the use of the term territorial jurisdiction is commonly used in this court. And you'll see it's...
Are you saying this article is reflected in the other case that you just about show me?
No, what's being said against me, Your Excellency, is that because in England you can do what's called serving out of the jurisdiction, that for some reason the principles that we have shown, Your Excellency, in our skeleton don't apply. Now that is wrong. That is a completely false point. And as I say, it doesn't matter whether you call it territorial, as mentioned by the Chief Justice, or personal, or subject matter jurisdiction. The important point is, whatever the label, the claimant, in order to get any order, must show that the second defendant is subject to the jurisdiction of this court. And all I'm showing Your Lordship is, Your Excellency, is that the use of the term territorial jurisdiction is a common...
Oh, no, my question now, what authority does this speech have now before me?
It's just to show it's just to make good the point that the term territorial jurisdiction is used in this court.
You just put it in a persuasive way.
Persuasive, exactly. I'm not in any way saying it's binding. All I am saying is, our point is a good one, and the word territorial is commonly used in this court. My learned friend says it's completely different in the DIFC to anywhere else, because there is a statutory jurisdiction. We don't mind whether it's called statutory or personal or territorial. What we say is you have to look at the law and you have to show that the law...
Well, he might be just like me, never read this article.
Possibly. He's very diligent in reading articles. But if Your Excellency would go to the Peter Gray case, and I just want to show you, Your Excellency, where it's... If you go to paragraph 9 of the judgment, you'll see the defence acknowledges the territorial jurisdiction of the DIFC court by virtue of this dispute arising from employment within the DIFC. So again, this is a judgment of this court.
What paragraph? 9?
9.
Yes.
The defendant, do you see, the defendant acknowledges the territorial jurisdiction of the DIFC court.
But this is not a judgment dictums. This is what the judge is trying to summarize. I mean, parties' submissions.
Yes, I agree.
Well, it's not the dictums, isn't it?
But, Your Excellency, I just want you to understand why I'm showing you this, because it's very important. There are two concepts.
Right.
There is the jurisdiction over the party, which is called either territorial, personal, subject matter. It doesn't matter what it's called, but you have to show that. And then there is also what's called substantive jurisdiction, which is the power of the court to make, for example, a freezing order. We don't dispute that there are broad substantive jurisdiction powers. In other words, that the court has a power to order a freezing order. We're not suggesting that the court doesn't have that power. But before it can exercise that power, it has to be shown that the court has jurisdiction over the second defendant in this case. And that's what we're showing. The claimant has to show that. Now, on the ex parte application, the two issues were elided together. They weren't distinguished. It wasn't made clear why they're saying that this court has territorial or subject matter or statutory jurisdiction over my client. Now, that's the important distinction between the two. You can't give the court jurisdiction by saying it has broad powers to grant a freezing order. You have to show that the second defendant is subject to the jurisdiction of this court.
Are you denying that this court has like an impersonal jurisdiction for a party who is located away from the territory of the DIFC? And that can be served without the permission of the court, so he can be brought before this jurisdiction, then he'll be given the chance to challenge it.
Yes, if you have jurisdiction under the statute. So if you go to the statute and you say, for example, we don't dispute that the court has jurisdiction in terms of enforcing a foreign judgment, but only against the party to that judgment, in this case the husband. But they don't have a judgment against my client, so they can't rely on that judgment, and that's the only thing they rely on.
Can we say this? Everyone in this world can be served with the DIFC court claim form or application or something, and then he would be subject of this court unless he come and challenge. I said, DIFC court, you got no jurisdiction based in the statutory provisions.
Well,
that's how it works, or this is very broad statement.
I would say that is a very broad statement. I could put it the other way around. This court only has jurisdiction in relation to those parties that fall within the law, Article 5, which I'll show you in a moment. And in this case, the only basis for asserting jurisdiction is the judgment. That's the only basis.
Excuse me, but tell me, who's going to stop anyone like suing X person in Brazil before this court? And then he said, would you please serve him? And then we gotta serve him, and then he come here and he said, I shall defend myself now. You have no jurisdiction.
That's what the claimant is saying. The claimant is in fact saying that they can bring anyone into this court, provided they've got a judgment against another party.
I'm very honest with you. I mean, I had a party standing here before me in your location exactly, and said, how can everyone in this world protect himself from being a subject of the DIFC court jurisdiction? He said this is extraordinary, jurisdictional, let's say, a setup.
Yeah.
He was calling for certain, amendment to the jurisdiction of this court, but he said, yes, how can anyone in the world protect himself from being subject to the jurisdiction of this court? But what he was calling for that is claim for can travel anywhere against anyone unless they come before this court and says, oh, we not fall within this statutory provisions.
Yes.
So it doesn't say either like territorial or personal, but you need to show that.
You need to
I'm not falling under any of these categories,
Exactly.
especially under the very wide A,
Yes.
51AE, yeah?
The thing that Your Excellency should appreciate in this case, the only head of jurisdiction relied upon is the English judgment against the husband. That's the only basis, they say. Of course, Your Excellency knows there are other bases on which you can bring jurisdiction. They're not in this case. That's the only basis. That is irrelevant to the jurisdiction against the second defendant. The fact that they have a judgment against somebody else, the husband, doesn't mean they have jurisdiction against another party. They may well be able to establish jurisdiction against the husband on that basis, but they can't establish jurisdiction against the second defendant. And Your Excellency is right. What they say in their skeleton is, and they say it several times, my client is the husband is my client, is the way they put it. But that is a claim. That is a claim. That is not, they don't have any judgment to that effect. In fact, what they told Your Excellency was they want to apply on the 21st of March in England for a judgment to that effect. They can't say that they have a judgment against the second defendant now.
Well, I think they already applied.
They have
They're
applied.
expecting judgment, I hear.
They have applied.
Yes.
They have applied, and we accept that. But they don't have a judgment now.
Yeah.
And they didn't have one when they came before Your Lordship on the ex parte. That's the important thing. I can't stress enough. You can't come to the DIFC court and say, I think I'm going to get a judgment, and I'm very confident I will get one, and I'm very likely to get one. You have to have one. Having one in the future is not good enough. You can only found the jurisdiction if you have a judgment. What they're trying to do is to say, well, we can bring a claim against anyone provided we have judgment against the husband. And that doesn't work in terms of jurisdiction. And the short point is, having a judgment against the husband is not the same as having a judgment against the second defendant. And there is very clear authority in this court that so far as the enforcement jurisdiction is concerned, it can only be enforced against a party to the judgment. And my client, the second defendant, isn't a party to the judgment.
We're not dealing with Peter Gray anymore, no? Is that right?
Sorry.
We're not dealing with Peter Gray anymore, the case.
No, Peter Gray is to one side.
Right.
I do want to show you some other cases, but not Peter Gray.
No.
That's just to show you labels don't matter.
Oh, I see.
But the point is, what they said to you on the ex parte is that they hope and indeed expect that they will get a judgment against my client on the 21st of March from the English court. The short point is they don't have one now. They didn't have one when they applied to Your Excellency. And there is a lot of authority of this court, which we've put in our skeleton, to show Your Excellency that having jurisdiction against one defendant does not give rise to jurisdiction against another. You have to, for this application, look at the jurisdiction in relation to my client. And having a judgment against somebody else, in this case the husband, is irrelevant to jurisdiction against my client. Because we're not a party to that English judgment. And they effectively admit that because they say they want to get a judgment on the 21st of March from the English court. They also say they expect that they will get one. But that isn't good enough.
No, they might not.
Well, they may not. But the point is, when they come before Your Lordship on the ex parte, they should have explained this. And they should have said, not that there will be a jurisdictional challenge, but there was no judgment against my client.
Yeah.
And therefore there was no jurisdiction to make an order. And that was important.
Well, I see. You're saying they must have a case
Yes.
against second defendant, right?
What?
What Mr. Black was arguing, they have a good arguable case so far against you, defendant.
Right.
But that, I think, it's another category of...
Very important, Your Excellency, to have this point on mind.
Yeah.
You can exclude all the other heads of jurisdiction. The only one they rely on is the judgment, enforcing the English judgment. Mm-hmm. So you don't have to worry about all of the other heads that might apply in other cases.
Yeah.
It's only the judgment.
Now, having a case is the same as saying you have a claim. And their claim is that the husband is the same as my client is the same as the husband. That is a claim, that is a case. They don't have a judgment to that effect, and they have to have that. They can't just have a claim and come to this court. They need a judgment to say that. That's very important. Just saying that my client is the same as the husband.
And you're saying that cannot be said to be a good arguable case in their favor?
They don't have a good arguable case at all. They don't have any case because having a claim is not the point. They have to show that we are bound. They are bound by the judgment. That we, not the husband, that the second defendant is bound by the judgment. And they haven't got a case on that.
Well, I see, but most of your argument are going like you want them to go in full separation between first and second defendant.
We are separate. I'm not representing the husband.
You have no evidence to this so far.
But
you put no evidence.
But it doesn't. Well, firstly, can I just say on that? I'll come to that in a
Yeah.
moment. There is evidence on our application, but it doesn't matter. Even if there weren't evidence.
Excuse me for interrupting you in your introduction. I know this is still the introduction, but
No, not at all. I think, Your Excellency, you're fair to ask that question. It's very fair to ask that question. But the fact that they've got a claim, even a good claim, and their evidence is good that they have a claim, the only ground on which they assert jurisdiction is the judgment. It's not that they have a claim, it's that they have a judgment. So the only question for this court is that judgment binding as against the second defendant? We're not even a party. So as matters were at the ex parte hearing, and as matters are today, there is no judgment against my client. And if there is no judgment, the only basis on which they apply is that there is a judgment. The fact that they have a claim is neither here nor there. There is no jurisdiction, unless they can show they're bound by the judgment, which they cannot. So the question of good arguable case is not whether there's a good arguable case they have a claim, it's whether they have any case that we're bound by the judgment. And that's very important, Your Excellency, because this is not a case where they could bring the second defendant into the DIFC and bring their claim. The claim is being dealt with in England, not in the DIFC. And the only reason they're here is because of the judgment. And it's very, very important. That's a very fundamental point. That's the only basis on which they can bring their jurisdiction. And so the fact that they say they have an application for a future judgment, that tells Your Excellency what they're really saying. They say to Your Excellency, we will be bringing a claim in England on the 21st of March, and we hope to get, and we expect to get, a judgment. That is completely irrelevant. In order to found jurisdiction, you have to have a present judgment against straight my clients, and a hope or expectation of a future judgment. However likely, even if they persuaded Your Excellency that they were very, very likely to get a judgment on the 21st of March, that is irrelevant, because they don't have one now, and they didn't have one at the ex parte. And so, Your Excellency, that is a very fundamental point. That's really at the heart of the matter. And if Your Excellency is with me, there is no statutory jurisdiction, territorial, personal jurisdiction over my client. The injunction has to be discharged. And that, in our submission, that is very, very basic. In our skeleton, I just want to take you through a few of the points in our skeleton and answer Your Excellency's question. The first point about today is, and I can take Your Excellency to the case, it's actually a case by the same judge who did the divorce proceedings in England. At the return date, the burden is on the claimant to establish that the injunction should be continued. So it's not my burden, it's his burden. And it's important for Your Excellency to understand, if we hadn't issued any application, if we had not issued an application challenging jurisdiction, all the points that I'm making to Your Excellency now, we would be entitled to make. We would be entitled to say, on the basis of their evidence, they can't establish jurisdiction. And therefore the injunction should never have been granted. Your Excellency should have been told the position on the law, and it shouldn't have been granted, and it shouldn't be continued today. Even if we had no application, no evidence, nothing. They have the burden, they have to establish it. And we've said, and I don't believe it's disputed, if it's an issue about jurisdiction, it's not about good arguable case. It's about whether we're right or wrong. We say they have no case, not even a good article case, on jurisdiction, because the only case they advance is the English judgment against the husband. They don't have an English judgment against the second defendant. That is fundamental. If Your Excellency accepts that, that is it. It's over. No injunction, no claim. It's over. So with that, I just want to take Your Lordship to the law, which Your Excellency adverted to. If you go to the claimant's original bundle of authorities and the judicial authority law at tab 14.
Is it 14?
Yes, tab 14, that should be the judicial authority law, 2004.
674.
Page 674.
I do have something else after 14.
Do you have, it's the claimant's first bundle that you had at the ex parte application?
No.
Your Excellency, you may recollect we had, at the ex parte, there were 4 bundles, 1A, 1B, 2A, 2B. The bundle 2B was the second bundle of authority.
I haven't got them.
Is that 2B?
I recall you, I haven't got them.
It's not before the court at the moment.
I know.
Okay, I think we've both referred to that, so perhaps we could pass up the bundles.
Oh, we've got a big one. Yes. That's better. Sorry. 674. I'll do the page, sorry, James. It's page 674.
I see that now.
Yes. So Your Excellency will know very well, but I just want to point out to you the heads of the jurisdiction of this court. And what we are saying is, it doesn't fall within any of them. But the good news for Your Excellency is, the claimant is not suggesting that any of the rules A to D apply. So they're not saying, for example, that this is a DIFC establishment or DIFC body, or that it's a claim that falls within the DIFC under B or C or D. None of those are applicable in this case. In another case, you might be able to argue that those apply, but happily, for Your Excellency, they are irrelevant to this case. The only one they rely on is E. Any claim or action over which the courts have jurisdiction in accordance with the DIFC laws and DIFC regulations. And then, if you go on in this bundle to page 679, you'll see the DIFC court law.
Right.
And if you go on in that to page 689, you'll see Article 24.
Right.
And that is ratification of judgments. And this is important because this is the provision that is relied upon in this case. Pursuant to Article 7.4 of the Judicial Authority Law, the Court of First Instance has jurisdiction to ratify, again the stress is on ratification, of any judgment, order or award of any recognised A, foreign court. And we accept that the English court is a foreign court for these purposes, and E, orders for the purposes of any subsequent application for enforcement in the courts of Dubai. Now those are the only provisions that are relevant to this case. And it's common ground that the only gateway relied upon by the claimant is the court's power to enforce foreign judgments. And so that's why we say, Your Excellency, the wife has the burden to persuade the court to find as a matter of law that the second defendant falls within the court's jurisdiction to enforce a judgment. Now just...
No, if you go back to the first law,
Yes.
and JAL law. If there is anything you would like to address me in Article 7 under the title execution before you move on to...
Yes, I can do that. That's a different point, which is...
Are you coming to that later?
Yeah, I was going to come to it later, but I'm happy to do that.
Whenever.
Because I think Your Excellency should know...
I can follow your order. I mean, you didn't have to change your...
no, but shall I just make the point to Your Excellency now, so that
Sure.
you'll come later? If you look at 676, it's a different point.
Right.
That is, where the subject matter of execution is situated outside the DLOC, the judgments, decisions or orders rendered by the court and ratified by the courts shall be executed by competent entity having jurisdiction outside the DLOC in accordance with the procedure and rules, as well as any agreements. And then it says at A, such execution shall be subject to the following conditions. The judgment, decision or order or ratified award is to be executed is final and executory. The important thing about that, Your Excellency, is this. Firstly, there is no judgment against my client, only against the husband. As far as we are aware, the judgment has not been ratified by this court, and what they have done is arrest the vessel on the basis of the freezing order, but Your Excellency will appreciate that a freezing order is not final and executory. So I'll come back to that later, but they've actually, even on their own case, they've adopted an improper procedure. And that's very important. I'll come to that, and I'll show you the arrest, the letter of execution later. But as we're in there, I just wanted to show you that.
So are you saying unless the English judgment first ratified in here, it cannot travel beyond this jurisdiction? That's what you're trying to say?
No, I'm not saying that. I'm saying there are 3 points. The first point is we're not party to the judgment at all.
Oh,
and the letter is against the second defendant as well as the husband.
Mm-hmm.
So they haven't established that. Secondly, the judgment must be ratified in order to have the letter of execution issued, and that hasn't been done. And thirdly, the freezing order is not a final and executory order. The letter has been issued on the basis of the judgment, but the freezing order is not final and executory. The freezing order is an interim order, and they've enforced that in the Dubai opinions. So that's very important to appreciate that. I'll come to that. I'm taking it slightly out of order, but that's very important to appreciate that as well. So all I wanted to say to Your Excellency about Article 24 is that relates to the ratification of a foreign court's order, judgment, or judgment. And it's important to appreciate that this court is simply ratifying what has happened in the foreign court. It is not revisiting the merits of the case. It is just giving effect to what's already happened. It doesn't even, it simply approves the judgment so that it can be enforced. And that is why it's so important to appreciate that because the court isn't revisiting the merits, there is no reason to conclude that the process of ratification should bind anyone other than a party to the judgment. And it's very, very important. We've dealt with it at some length in our skeleton. But because it's a ratification of a judgment, it can only be a ratification of the judgment against the party that is bound by the judgment. And the judgment binds the husband. It's against the husband. It is not against the second defendant. And I'll just show you, I don't know if Your Excellency had a chance to look at any of the cases that we cited, but there's a decision of justice.
Can you tell me, like,
Yes.
what's the best form of procedures? A case where, like, a foreign judgment is sent to certain jurisdiction,
Yes.
where it's believed, let's say, that the defendant hides his assets and deliberately try to evade or do whatever with his assets.
Yes.
So how the foreign judgment can be like enforced where, let's say, the claimant just found out the defendant is hiding or doing something with his assets, transferring that asset like into another name. How the claimant can like take the judgment to that territory and start investigation and then convince the judge, Oh, this is just mere dissipation of asset that's supposed to be available to international justice.
Let me explain to you.
Yes.
They have the judgment. What they obtained was a judgment against the husband. They have a judgment against the husband. They brought it to this court. I don't act for the husband. I don't represent the husband. That's the judgment they have. And that is the judgment they can enforce. And if they're saying the husband has done something wrong, as they do many times in their skeleton, they have lots of points about the husband, what he has said, what he's done, that is completely irrelevant to my client. There is no judgment against my client. Now, if they get one in the future, and they then seek to enforce that judgment, that may be a different matter. As matters stand today, there is no judgment. And that's the only basis upon which they can come to this court against my client.
No, I think you're not answering my question. What I say, in a hypothetical case, okay,
Yes.
the claimant believes there is a fraud in certain jurisdiction. We know there is an asset for the defendant in certain jurisdiction, but we believe there is a fraud. There is a dissipation happening, there is the defendant trying to hide his asset by putting it under another name or another mask.
Yes.
So the foreign court cannot go to that jurisdiction and investigate under the enforcement procedures. I think, well, and this is again a hypothetical, I think only the local court, which has the jurisdiction in territory basis maybe,
Yes.
okay, can investigate and say, yes, this car, this building, or this money, or this account is in fact related to the defendant, not to this new third party come up to the surface. It's just a mask. So only the enforcement court can investigate this. Is that right or wrong? And this is the only basis where this like international judgment would like have a special treatment when it's come to the dissipation of defendant assets.
I think what's very important to appreciate is it's a fraud against whom and by whom. In this case, the principal claim is between the husband and wife, obviously. The wife has obtained a judgment in England. You can't, on the back of that claim, or any claim, then bring in other people as if they are a party to that claim. So you have to analyse it and say, in each case, who is the claim against? In this case, there is a claim against the husband. They have a judgment against the husband. But it doesn't follow that having a judgment against the husband means you have judgment against other parties. That's the fundamental point. And so, in a sense, the hypothetical doesn't arise. If you're saying, can the wife pursue the husband in various jurisdictions, I have nothing to say about that. I am not representing the husband. My point is a very simple one. So far as my client is concerned, a Liechtenstein company. One answer to your Excellency's question is, the wife has shown herself perfectly capable of issuing proceedings in Liechtenstein. She can sue us there. She can sue my client there if she feels she has a claim. And there have been proceedings in Liechtenstein. But what she cannot do under the laws of this court is bring my client into the DIFC jurisdiction. Because the only basis that she can do that is the judgment. That's the only basis which she's even claimed. And she doesn't have a judgment against my client. It's as simple as that.
Well, this is always enforcement about reality. He said, okay, I have just found an asset somewhere in the world. Well, I need to freeze that asset until I will be able to pursue a claim. Doesn't matter where in jurisdiction, another jurisdiction where the asset is found or where the party is located, okay, where the jurisdiction can extend against him, whether in tutorial or in personam or whatever, you know what I mean? But he said, I need to do something. I need to preserve what I think.
But then, if she really does have a claim, she could bring a claim against. We're a Liechtenstein entity. Bring a claim in Liechtenstein, if that's the case. What you can't do is ignore. What's fundamental to this court is the definition of its jurisdiction in its own rules. And what the claimant is doing is to say, well, this is very unfair. The wife has a judgment. It's unfair that she should be in this position. But you can't, on the back of that, simply bring entities in, as Your Excellency was saying, where there's no limit to this. You can bring a claim against anyone, a company in Brazil, in Tonga, in Australia, in New Zealand. Just bring them in. You have to follow the rules. And the rules are very important. And the rules have to be followed. And the
Oh, sorry, who has to follow the rules? Is it the court or the parties?
The court and the parties, both. But the court must follow its own rules as well. It's very important to appreciate that, because otherwise there are no limits. And the statutory jurisdiction is very clear. And in a sense, Your Excellency's job is easy. And the reason it's easy is because the only basis on which they bring it is the judgment. If they had a judgment when they came to you on the ex parte against my client, that would be different. They would come to you and say, we have a judgment, not we think we'll get one, we expect to get one. They had one. Then they could properly invoke the jurisdiction of this court. But they can't just come here and say it's much fairer, is what they're saying, if the wife could enforce against my clients. That would be fair because she has a judgment against somebody else. You have to go through the hurdles. And the rules must be obeyed. And they haven't. They simply haven't done
Well,
it.
I got your point. It's probably not the answer that I wish to hear, but
yes,
I got your point.
And of course, I understand because the court wants to do justice in every case. And I know that Your Excellency particularly wants to do justice in each case. And that is at the forefront of every judge's mind, particularly Your Excellency. But justice is not just about the justice in each particular case, fairness or otherwise. It would be unfair to other litigants, to other people, if you could just have an exorbitant jurisdiction. You get a judgment against A, and you can bring in B to Z, and say, well, they're all party to this, and they're all helping the husband. You cannot do that. It's totally impermissible. And with respect, this should have been explained to Your Excellency. What Your Excellency should have been told is to go through the rules, to say that if my client had been there at the ex parte, they'd have said exactly what I'm telling Your Excellency now. It's a very basic point. It's not a question of how broad the jurisdiction is to give a freezing order. It's how you get jurisdiction over my client. And that was really very important. It's not enough to just say, oh, well, they would have come along and said, you don't have jurisdiction. They had to tell Your Lordship about that. It's very, very important. To show Your Excellency how important it is, can I show you this? I should show you, I was going to show you Justice Field. Justice Field's judgment if you go to our bundle of authorities at tab 5, Barclays and SR. This is to show Your Excellency why it's so important that only a party to a judgment is bound.
Sorry, behind tab what?
It's tab 5. It's our bundle.
Barclays case?
Barclays, exactly. And it's His Excellency Justice Field's decision in this court. And can I ask you, rather than read it out to Your Excellency, if you go to paragraph 21 at page 9, if you could just read that paragraph all the way down over to the following page, the whole of paragraph 21.
Yes.
So he then if you turn on to paragraph 35, he then relies upon those extracts to reach his conclusion. And what he says is, in my opinion, it is plain and obvious that the recognition of foreign judgments by the DIFC courts is not a matter of foreign policy conducted between states. Instead, it results from a rule which is a rule of private commercial law based on a private, voluntary or consensual or quasi-contractual obligation. In other words, he's saying it's like a contract assumed by the party to be bound, and then he refers to the passage you've just read.
Yeah.
The fact that the ultimate justification for the rule may be based on the very broad notion of international comity identified by the Court of Appeal of England and Wales in Cape Industries, which is what I'm sure Chief Justice Wang had in mind in the DNB Bank case, is nothing to the point. After all, the rule that an agreement in the nature of a contract is enforceable is nonetheless a rule of private commercial law, notwithstanding that its theoretical underpinning is often said to be based on the universal principle of pacta sunt servanda. Now, the important point there is that the judgment needs to be construed in light. The obligation is quasi-contractual or contractual. So when one looks at the judgment, the question is my client party to it, as if it were a contract? The answer is absolutely not. And that is why they say that they're going to England to get a judgment against them, because they don't have one now. Before I move on, I should just say one thing. Your Lordship was talking about the general problem of enforcement against assets. I think one thing to bear in mind in this case is the asset is not in the DIFC. It is not a DIFC asset. If the asset that the wife was claiming was said to be owned by the husband was a building in the DIFC, it might be different. But here it's the Dubai courts that have the asset within their jurisdiction, not the DIFC courts. Very important. So in a sense, Your Excellency's question is really an issue for the Dubai courts because the ship is within their jurisdiction, not within the jurisdiction of the DIFC court. That's an important thing to bear in mind. In a sense, it's not Your Excellency's problem. It's the problem of the Dubai courts as to how to deal with that. But at the moment, they've been served with a letter of execution based on the freezing. But it's important to bear that basic principle in mind. The other point Your Excellency made was, I think, was effectively, isn't it best if the court does its very best to help someone who has a judgment? And that's what they're really effectively saying, is bring in other parties because we want the court to help. Now, it is a cardinal principle that if there's any ambiguity about jurisdiction, it is resolved in favour of the person challenging jurisdiction. And that's an English case, which is in the same bundle in tab 14. It's a decision of the Commercial Court, Mr. Justice Mayles, in a case called Cruise City and Mauritius Holdings. And if you turn to paragraph 15 of that judgment.
Yeah, what bundle? The old bundle.
The point about this is, Your Excellency was saying, effectively, one looks at the rules, but maybe one should give them a broad interpretation. We say you can't do that because the rules are very clear. In fact, the jurisdiction is concerned, territorial. It's the other way around, which is any doubt is resolved in the favour of the person who challenges jurisdiction, not the claimant, but the defendant who says, I'm not party. So if there's any doubt about the interpretation of the
that right in jurisdiction in general, is that right? It's not about freezing orders.
No.
Is it related to the freezing order or just in
it's
general?
the other one. It's the first stage. So think of it as stage 1 and stage 2. Stage 2 is what's called substantive jurisdiction, which is, and we accept that this court and the English court have very broad freezing order powers. We've already, as Your Excellency knows, we've disclosed our assets because that was required in the order. In terms of substantive jurisdiction, the powers are broad. The power of the court to issue such an order, yes, that is broad. Stage 1 is, can you issue an order against that defendant, that particular defendant? What is the jurisdiction? So it's stage 1. It's the statutory jurisdiction, the territorial or the personal, whatever you call it, is stage 1. And this is addressing stage 1.
Okay.
And the principle...
What is that again?
It's in tab 14 of our file. And it's a case called Cruise City.
Yes.
And what the judge says there, Mr. Justice Mayles in the Commercial Court in London, says a cardinal principle.
When you're reading?
It's right at the bottom of this paragraph 15, at the bottom of page 791. And what is said is,
Where is the number? It's a top number.
tab 14. This is our bundle. It should be a case right at the top. It says Cruise City 1 Mauritius Holdings.
Are you referring to paragraph 15?
Yes, 15.
Yes.
And it's under the heading a cardinal principle.
Right.
So a very important principle. In this context, a principle of construction established for over a century is that any doubt as to the correct construction of the jurisdictional gateways ought to be resolved in favour of the foreign defendant. And he refers to a case called the Hagen, decided in 1908. And this has often been affirmed. He cites another case, Arab Munshi from Hashim, and is included in the leading textbooks, Dicey and Morris, which is described as one of the 4 cardinal principles applicable to service out of the jurisdiction. Now, Your Excellency knows that in England, not only is there a territorial jurisdiction in the sense of within the country, but you can serve defendants out of the jurisdiction if you fall within certain what are called gateways. Now, what my learned friend, what the wife says in relation to this is, but in the DIFC you don't serve out. As Your Excellency said, you just serve anyone who falls within the statutory rules. But the point is the same. If there's any doubt about how you construe the rules, you construe those in favour of the foreign defendant. So in other words, it's the other way around. If there were, we say there's no doubt anyway. It doesn't matter, because it's clear that there is no judgment against my client, only the husband. But if there were any doubt, it's resolved in favour of the foreign defendant. In other words, the court shouldn't take jurisdiction unless it's clear. And if there's any doubt, it's resolved in favour of the foreign party. And we say it's...
Just for a matter of information, I mean, before the English court, where I know the court has to give you permission to serve outside jurisdiction,
Yes.
after you convince the judge or the court, there is a jurisdiction. But if you correct me, also the defendant again, after being served, can challenge the jurisdiction again before the court. Is that right?
Yes. But
How it works?
But you have to show the court that you've got grounds to get permission to serve out.
First of all.
First of all. So you get permission to serve out.
Then even if you bring the defendant in, so he still can challenge the
You
jurisdiction.
challenge
That's
the
how
jurisdiction.
Right.
And that's what we say frequently the case on a freezing order, you get a challenge to jurisdiction dealt with at that stage. Just to show Your Excellency, if you go to tab 19 of that bundle, just to show Your Excellency the English rules, we have the same rule in terms of a foreign judgment.
Yes.
And you'll see tab 19 under practice direction 6b on the second page. If you go to the end, subparagraph 10, and enforcement, a claim is made to enforce any judgment or arbitral award.
Yes.
And the English authority, so that's our equivalent of Article 24. Now, if you turn back to 18, you'll see an extract from a book on commercial injunctions. And if you turn in that tab to page 452,
Yes.
and you'll see at the bottom of the page, the gateway in paragraph 3.110, which is the one Your Excellency has just seen, relating to enforcement of a judgment or award, is available against the judgment debtor or the person against whom the award has been made. That's the point we're making. That's the English rule. And it's not limited to where there are assets within the jurisdiction or about to come into the jurisdiction. It does not apply against a third party against whom there is no judgment or award. So we're not making a submission to Your Excellency that's in any way unusual. If you get a judgment, you can enforce it. but you can only enforce it against the party to the judgment, not somebody else. And that, in our submission, is very, very clear. Now, one of the things that they do say is that, well, all of this doesn't matter because they can bring a Shabra claim. And I don't know if Your Excellency saw that in the arguments. They say, well, even if we don't have jurisdiction, you can bring this Shabra claim. Now, I hope Your Excellency has seen our skeleton. There is a very clear case law that you cannot do that. And that is a case, the best case is a case called Valletta. And I'll just, if Your Excellency turns to that, it's in tab 10. And it's a decision of Mr. Justice Flo.
Tell of your bundle, is that right?
Yes, of our bundle. Same bundle. And the facts in that case are very similar in principle to the facts in this case. So the judge in that case had the same difficulty Your Excellency has in terms of being fair, bringing in people, would that be the right thing to do? What happened in that case is that the claimants obtained a judgment. I'll just tell you a logic of facts so that you can put it in context and then I'll show you what the judge says. The claimant obtained judgment against the first offendant in Italy for fraud. And the first offendant was Italian, and again, the person against whom the fraud was perpetrated was also Italian. So it took place in Italy. The claimants got a worldwide freezing order in London from the commercial court, partly because the first offendant had been living in London for some of his time. And that was granted because the English court has a power to give injunctions in aid of foreign proceedings. Under Section 25 of the CJJ. It's a statutory power which the DIFC court doesn't have. But the English court has the power to give a freezing order in aid of foreign proceedings. Now, the claimants later discovered that in breach of the order, in breach of the freezing order, the first offender had dissipated its money from bank accounts in Monaco. So he had accounts in Monaco, and he took money out, and that was a breach. And his parents, the fifth and sixth defendants, were resident in Italy, and they were involved in the management of the accounts. And what happened was the claimants got an order against the parents ex parte, and permission was given to serve out of the jurisdiction. And the parents then came and applied to set aside. And those, as Your Excellency can imagine, those give rise to the same sort of issues that we have here. The parents were involved in the accounts, the freezing order was against them, they applied to set aside. Now what Mr. Justice Flo, the judge, found was there was no jurisdiction, either under what was called the necessary proper party jurisdiction, which is again a jurisdiction held in England and not in the DIFC. So there is a power in England to bring a claim if you say that somebody is a necessary proper party to the subsequent claim. So that doesn't work because the claim is being brought in Italy. That's where it should be brought. Or under the enforcement jurisdiction. And he says that if you look, if you go to 36 of the judgment, paragraph 36, conclusions as to territorial jurisdiction.
What page is that?
That's page 540.
What paragraph are you looking at?
36. So it's conclusions as to territorial jurisdiction.
Yes.
So again, it's stage one, if I can put it that way. Is there jurisdiction over the parents? The argument on behalf of the claimants that paragraph 3.13 of the practice direction applies is ingenious, but as I see it, fundamentally flawed. In my judgment, Mr. Samet is correct in submission that the application of paragraph 3.13 of the practice direction is limited to cases where the substantive dispute is before the English courts, because only in such a case is any claim going to be tried between the claimant and the defendant who has been or will be served with the proceedings. Whereas in the present case, the substantive issue will be tried in Italy, there never will be any real issue between the claimants and the first defendant, which this court will try. And then, if you turn on to paragraph 42, he says, equally, the short answer to any reliance upon that paragraph is that there is no claim against the parents to enforce the judgment obtained against the first defendant in the Milan court. At most, the claim against the parents is for ancillary relief, to assist the claimants to enforce the judgment against the first defendant, but as against the parents, that claim falls outside subparagraph 2. So in the present case, the DIFC does not have a necessary and proper party jurisdiction, and my client doesn't fall in the enforcement jurisdiction for the very same reasons that the parents did not in Belletti. So it's, in my submission, very clear that straight establishment, my clients don't fall within any of the territorial gateways. They don't get into stage 1, and the DIFC cannot then make any orders in relation to it.
But I don't know, I just feel it's a completely different case.
Well, it's not a different case, because in that case, if the court could simply apply a general power against a party who isn't party to the judgment, it could have done that in that case, and it didn't do so.
See, that is application first to serve outside. Second case, I mean, in our case, the assets is located in Dubai. The DFC need not to serve outside the jurisdiction.
Yes.
The assets said to be belong to the original first defendant anyway, but it's under a certain mask of it. I don't know. I just
Can you look at 44 as well? Because this is the case they should have shown you on the Shabra jurisdiction. Because they made exactly the same argument in this case about
44?
Shabra. So if you look at 44 at the top of 542,
yes.
I turn to Mr. Chambers' arguments as to why the court does not need to be satisfied that it is expedient to make an order against the parents before doing so. The argument that Section 25.2 of the 1982 Act does not apply because the court has Shabra jurisdiction against the parents under Section 37 of the 1981 Act fundamentally confuses substantive jurisdiction in the sense of the powers of the court against those over whom it has territorial jurisdiction. So same as this case. So it confuses the power to order, make an order, and territorial jurisdiction, with which Section 25 and the Practice Direction Part 6 are concerned. In this case, territorial jurisdiction is Section 5 of the statute. So here it would be judgment. The two have to be separated. And that's what the court clearly says here. You have stage 1 is their jurisdiction over the party, and stage 2 is their substantive jurisdiction, i.e. the power to make the order. And the idea that you can get that by saying, invoking the Shabra jurisdiction is wrong. And the judge says that very clearly. So this is very similar to our case, because they argued the same point, which is what they were saying to the judges. Well, it's very fair.
But it's interpreting another provision of law, jurisdiction, and enforcement.
Well, except that you're right in one sense. In this court, we don't have the service out provisions. But that's all the more important that the court has to construe the statute carefully. What they're saying in this case is that you can look at the enforcement jurisdiction and you can bring in a party who is not party to the judgment. And that, in my submission, is completely wrong. The other thing that they say is you can bring them in by way of the Shabra jurisdiction. But this case makes it very clear you can't do that either. The Shabra jurisdiction doesn't help them because they have to show there's jurisdiction at stage 1. They have to show the statutory jurisdiction. So it is the same point, for instance. It's exactly the same point of principle. It's true that the rules are different, but the principle is the same. It's the difference between territorial and substantive jurisdiction. And 44 is very, very important. And I just want Your Excellency to appreciate that I've shown you the practice direction 3.110. The rules in England and in the DIFC are the same in terms of the enforcement of the judgment. Those rules are the same as Article 24. So those two things are equivalent to one another. So it's not a different case in principle. And Excellency's question about the location of the asset, it is important to appreciate that the asset is not within the DIFC. It is not here. It is in Port Russian.
I see.
I do actually want to show Your Lordship the decision of Justice Giles on Nest Investment.
Can you tell me if Chaburu cannot apply to that example, when it can be applicable?
It can be applied if you have territorial jurisdiction. So if for example, you were dealing with a DIFC body where the court has jurisdiction, but there wasn't, for example, a cause of action against that entity, the court would have territorial jurisdiction over
Well,
that
you're
entity.
saying the court of the merit, only the court would investigate that relation between parties.
As long as the court had actual territorial jurisdiction. So, for example, in England, if you were domiciled in England, the court has jurisdiction over you, could then make orders. In the DIFC, you have to fall within one of the Article 5 provisions.
Even at enforcement level.
Even at enforcement level.
But how let's say, how a foreign court would make an investigation
That's-
about an asset
Right.
and another investigation?
Well, that's the point I just made, which is where is the asset in space? If it were a building in the DIFC, that would be a different matter, because you would then say there's subject matter jurisdiction. But the vessel is not in the DIFC. What they're doing is attempting to use the conduit jurisdiction, coming here with an English judgment against the husband, saying that applies to my client, a Liechtenstein entity, and yet there's no stage 1 jurisdiction against my client. It would be different if there were jurisdiction over the entity under the rules, but there isn't. And the enforcement issues would be an enforcement issue for where the asset is located. Now, Your Excellency question was a good one. When does Shabra apply? Shabra applies, as Mr. Justice Flo makes clear, where there is territorial jurisdiction. You can't apply Shabra unless you have stage 1. The point fails for the same reason. Basically, what it boils down to, Your Excellency, is a very simple point. The only thing that Your Excellency is concerned with is the English judgment. The English judgment is only against the husband, and it's clearly construed as such. And that is the only jurisdictional basis for the claim. That judgment's against the husband. There is no judgment against the second defendant. There is no stage 1 territorial jurisdiction. And that means that there is no jurisdiction to make any order, either on the basis of Shabra or on any other basis, because they have to show that stage 1 jurisdiction, and they can't do that. And then, in terms of the broader issues, Your Excellency says, well, what about the injustice to
But
the
are you holding on to the argument that the English judgment is still not ratified before this court?
They're two separate points. I'll come back to the order of execution later. They're two separate points. There is our fundamental short point is a very simple one. There is no stage 1 territorial, personal, whatever label you give it, jurisdiction. There is none. And therefore there is no jurisdiction to make any orders at all of any kind. I just want to show you tab 4 of our bundle, Nest Investment, which is Justice Giles' judgment. Just to make clear the point I am also making is, in this court, in the DIFC, you cannot found jurisdiction against the defendant by saying another defendant, there's jurisdiction against another defendant. You have to look at each defendant individually.
Go ahead.
If you go to paragraph 13 of the judgment,
Yes.
the claimants did not submit that there is present jurisdiction to hear and determine the claimants against Mr. Fuggle under Article 5A1A, because he is another party to an action to which DTME is a party. Correctly so, since claims or actions in Article 5A1 addresses the particular defendant, and then it relies on Al-Kharafi, which is in tab 3 of our authorities bundle. And if you...
So what's the judge is basically saying here?
What the judge is basically saying here is, you have to look at each defendant. You can't say that the court has jurisdiction over the defendant because it has jurisdiction over another defendant. So in other words, if you bring a claim against 6 defendants, you can't say Well, we've got jurisdiction against defendant 1, therefore we've got jurisdiction against other defendants.
And what's the link established between the two defendants in this case?
In this case, it was because he is another party to an action to which DTME is a party. In other words, he was party to another action, and therefore the court had jurisdiction over him on that basis. What the judge is saying is you have to look at each defendant to see whether they've stayed on territorial jurisdiction under the statute. And you'll see that also in Karafi in tab 3.
Yeah, no, I understand Karafi.
Yeah, I'm sure you can. If you you know it well, if you would go to paragraphs 80 to 83.
Same delivery?
Yeah,
Oh, Karafi.
yes, correct. Page 21 and 26. I know Your Excellency will know this judgment very well.
Karafi with behind what tab? Is it?
Yes, it's at tab 3.
Yes. Allow me to
It's
write.
the same point that Justice Giles was making in 80 to 83. And there was an alternative case under Article 5A1A. Are you at paragraph 80?
Not yet.
It's page 21.
'81.
Yes, 80. As we are under the claimant's alternative case under Article 5. As we have already indicated, this is very much a fallback solution, which we no doubt originated in a similar provision of Law 12. It is, however, an entirely misconceived application of Article 5A1. Saracen Switzerland is not a DIFC body, or a DIFC establishment, or DIFC licensed establishment, nor is it a party to any claim against Saracen Dubai, which is a DIFC establishment or licensed establishment. It is necessary for the purposes of this provision to show that there is a claim for a remedy by or against a party which falls within one of the 4 identified categories. It is insufficient to rely on the fact that a different party to that against which the claim in question is brought.
Isn't this overruled at the end?
I don't think this part is overruled.
You sure?
Yeah. Yes. Yeah. Very sure. But it wouldn't be over. There's no reason for it to be overruled, and it's been followed by Justice Giles. So it's very this is called for yes.
This Coach Fabio,
Yes.
C5.
Sorry, if I can help.
You were sitting there in the court.
Yeah.
Mr. Black was in the case.
What I can help is, I think what Your Excellency is thinking of is, while the Court of Appeal did find that there was an effective jurisdiction clause in that case, they nevertheless overruled the jurisdiction clause, and I think that's what you're thinking of.
Yes, yeah.
But this is about the construction of the rules. And this is a very, very important point, because what it says is, at the last sentence, it is necessary for the purpose of this provision to show that there is a claim or remedy by or against a party which falls within one of the 4 identified categories. It is insufficient to rely on the fact that a different party to that against which the claim in question is brought happens to be a party to the proceedings. So in other words, in this court, it is very important to look at it on a defendant-by-defendant basis. And you can't bring defendants in by reference to other defendants.
Yeah, but it was not argued. This is like this entity was a mere mask for the other entity, so it's different.
Well,
this is what we don't have in this case.
No, that's right. But remember, in the present case, in our case, this case that you're dealing with, the only head of jurisdiction, you don't have to look at the other Article 5.1a. The only head of jurisdiction is the judgment head. That's the only head relied on. So the only question for the court is my client party to that judgment, bound by that judgment? And the answer, in my submission, is obvious to that. The answer is no. And you can see that from the fact that they're applying on the 21st of March in England for judgment against my client.
Well, I still believe, whether or not the application of Shabro principle, I think is very important to this case.
Whether Shabro...
What you just addressed me.
Yes.
Yeah. Oh.
And the reason Shabro doesn't apply is it fails for the same reason. So Shabro cannot apply unless the court has territorial jurisdiction. In other words, it's the same point. This court can only make orders against a party if it comes within its territorial jurisdiction. That means in this case, simply whether it's party to the judgment. Now, if Your Excellency accepts my submission, and I would submit that it's unanswerable, my client is not a party to or bound by the judgment, then there is no jurisdiction. And you can't rescue that jurisdiction by shadow, because as Mr. Justice Flo made very clear, it's the same analysis. You can only invoke shadow if you can show that there is territorial jurisdiction. In other words, the court has jurisdiction over that party. So it fails again. So there is, in my submission on jurisdiction, there is simply no answer to my submissions. There is no power in the court, there is no territorial jurisdiction, and my client is not bound by the judgment, and that, in my submission, is very clear. Now, I know that Your Excellency is also concerned with general injustice, and we say, firstly, one has to follow the rules. The rules are important, and the consequences follow, and they follow for all litigants in all cases. So this exercise must be done. But there isn't really any injustice to the wife, because my client is based in Liechtenstein. She can bring proceedings in Liechtenstein, and if I can just show you in bundle B, page in the first bundle, in the bundle on the ex parte, in Mr. Tripoli's exhibit, if you go to page 119, which in my bundle is tab 9, maybe tab 8 in Your Excellency's bundle.
Nine, sorry.
Yes, I think maybe tab 8 of yours, but it's the exhibit.
The affidavit?
Yeah, and it's page 119.
I didn't have your vagination, but I have.
Do you see 119 should be headed Principality of Liechtenstein?
No, I didn't have 119 vagination, but I do have some affidavit of Mr. Sanders.
It's the exhibit. It's behind that, I think. It's either the next tab or behind the affidavit. Yeah, the pagination starts on the exhibits.
I don't know, I just see Tamimi letter behind that.
I think it may be, is your bundle tabbed? I think it may be tab 8.
Tab 8, the draft order only.
No.
Or maybe I'm looking to another bundle.
The ex parte bundle this is.
Are you referring to ex parte?
Yeah, that's the ex parte bundle. Maybe you don't have that. But
Yeah, I don't have that. So.
Yes, 119. Do you see, it says Regional Court, Principality of Liechtenstein.
Right.
And the point we're making here is, you see the applicant is the wife,
Right.
and the respondents are two Liechtenstein established Quobo 1, I hope that's the right pronunciation, Quobo 2, Cubo 1 and Cubo 2. The point being that the wife brought proceedings for a restraining order and mandatory injunction in Liechtenstein. My clients are based in Liechtenstein. She's fully able to bring a claim for injunctive relief if she's entitled to do so in Liechtenstein. And it's very surprising that she brought the claim here rather than where my clients are based in Liechtenstein. But there's no injustice. As your Excellency is saying, if you want to...
Excuse me, what claim you're talking about? We have just a freezing injunction to serve what's going to be claimed in the future. I don't know where else. I think we have another situation.
Well,
he didn't say that he's not going to Liechtenstein and sue your client. I don't have that before me now.
No, I agree. But
what is the point?
The point is that the wife can bring proceedings in Liechtenstein and has done in relation to different entities. It's not as if we succeed as we should, the wife has no remedy. If she wants to bring proceedings in Liechtenstein, she can bring proceedings in Liechtenstein and she can obtain mandatory injunctive relief if she's entitled to it. So it's not as if it's either the DIFC or nowhere. The wife can bring a claim in Liechtenstein if she's entitled to do so.
Yeah, it can be.
But Your Excellency is right.
Well, what we're doing here is just attaching over an asset. It might be
Yes.
subject of enforcement in favor of Ms. Akhmedova.
But remember, Your Excellency puts it very well.
Well, I understand. I just want to say it's not a substantive claim. It's just an injunction
Yes, you're right.
that might serve a claim.
Well,
Where else in the world?
the point is, I think Your Excellency is absolutely right. The only way in which they put their case is as a claim, but the only way they bring their application for freezing order in the DIFC is on the basis of the judgment. Having a claim isn't enough. It doesn't found jurisdiction, and the only basis for the jurisdiction is the judgment. So it's very important for Your Excellency to put to one side the fact they may have a claim, and they may get a judgment. They don't have one now. They don't have a judgment against my client now. They only have a judgment against us.
Well, we will hear from Mr. Black where he intended to have a judgment against your client, whether in England or Liechtenstein.
Well, he's told Your Excellency, and it's said in the evidence, that they have a hearing on the 21st of March in England where they want to obtain a judgment against my client. But it's obvious from that they don't have one now, and they didn't have one.
Right, yeah.
That's the point. That's the point. The fact they may get something in the future is neither here nor there. They had to have it when we came before Your Excellency, and they didn't. Yes, the reason I'm showing you this claim against other parties is...
Yeah, so you wanted to show me that the Liechtenstein jurisdiction is open to the
Yes,
claimants.
that's all I wanted to do. It was really Your Lordship, Your Excellency's hypothetical question. What would happen? And the answer is, there are remedies. They can obtain, they can seek, at least, injunctive relief in Liechtenstein if they wanted to do so. So, Your Excellency said, oh, well, maybe there's Schaubler jurisdiction. The answer is there isn't. Valetti makes that very clear. And another case of Linzer, which is another judgment, Mr. Justice Flo, it's in our bundles. I won't take it to you. But the position of the authorities is very clear. So far as Schaubler is concerned, the court has to do the same analysis. Stage one is, does it have jurisdiction over the party? And for the same reasons, here it doesn't. All they have is a judgment against the husband, nothing more.
Mm-hmm.
They don't have any judgment against one of
I agree. This is only what's before us today.
Yes, and that's the case that's advanced. He doesn't satisfy. I do want to show you about the full and frank disclosure, because we do say that this wasn't explained to Your Excellency on the.
Yeah, but you might go through this, but I'm not going to spend a lot of time talking about it, because if your original case failed, that means even the disclosure you're referring to is not the right one, so they didn't have to disclose it to me. You know what I mean?
Yeah, I do.
Yeah,
But
well, go ahead. I shall not.
I'll tell you why it's important, Your Excellency, which is, let me go to our skeleton at paragraph 33, and I'll do it very briefly. I won't take you to the cases, because we've set out the cases in our skeleton. I just want to show you what was said at that hearing about jurisdiction. If you look at our skeleton at paragraph 33, it's page 11.
Give me a second. Paragraph 33?
Yeah, 33. So in Mr. Tripoli's affidavit, the claimant said, there is an argument that the DIFC has no jurisdiction over Strait, and that any judgment obtained against Strait may not be enforceable at common law for the reasons stated more fully in Ms. Akhmedova's skeleton argument. So all Your Excellency is being told there is that there may be an argument, but you're not told what the argument is. Then at 33.2, in the claimant's skeleton argument, the claimant merely mentioned that the second defendant was likely to have an argument that it does not fall within the scope of the court's jurisdiction to ratify foreign judgments under Article 24. The claimant contended that the answer to the point was that the claimant had a good arguable case that the court had substantive jurisdiction. Now, we don't dispute that the court has the power to order a freezing order, but Your Excellency's seen the cases. There's the Stage 1 analysis of territorial jurisdiction. And that, if we had been there at the ex parte, we would have made the same points that I'm making to Your Excellency today. That wasn't made. In respect of the claimant of the defendant, and that the court has jurisdiction under Shagra, and thus the court could grant an order against the second defendant in any event. And it was important in my submission to show Your Excellency the letter and the decision there to show that Shagra doesn't give the court jurisdiction if there isn't jurisdiction of the second defendant. The argument we're making is a very simple one, Your Excellency, is the only thing they rely on is a foreign judgment. It's only against the husband, it's not against my client, and therefore they don't get home at all.
So you're saying the statement in Mr. Tricoli's affidavit, when he said there is an argument, he didn't say there might be. He said there is an argument that the DRC has no jurisdiction over a strait is not enough, and then they have to go in full detail.
Not full detail, because this is a short point.
You want them to put themselves in your shoes and just deliver a litigation like the one you're doing now.
Well, and they could say in one paragraph, they could say the argument would be that the husband, when the judgment is against the husband, it is not against the second defendant. As it's not against the second defendant, the DIC doesn't have territorial jurisdiction, and Shagra won't rescue it because you need to establish territorial jurisdiction against Shagra. That's all you have to say. Not that there is an argument.
Well, actually, they said this is two separate entities, and they said then this is the link. It is a mere mask, one for the other one. Yeah, they didn't say why Shabara might not be applied to this case. Yeah, I didn't see, but they might still argue that.
Yeah, yes, but Your Excellency is entitled to be told what the argument is. So what they say in the skeleton is they have a good arguable case that the court has substantive jurisdiction. But Your Excellency knows that's not the point. The point is how do you even get to substantive jurisdiction?
Well, if they come and say Shabra is not applicable, then they won't use it as a provision that to support their case.
But the point, Your Excellency...
Well, it's a bit difficult. I think, I don't know. But we'll see. Let's see if your argument about Shabra...
Well, the point is...
Could be right.
Whether we I hope Your Excellency has our point, and in my submission it's a point that really there's no answer to. But even if Your Excellency were to say that we were wrong, the argument still has to be put to Your Excellency on the ex parte application. Not that there is an argument and we say we have a good argument case about substantive jurisdiction. We need to say that what will be said against us is obvious. The second defendant is not a party to the judgment, therefore there is no jurisdiction, and you can't get around it by Shabra, because you still have to establish territorial jurisdiction. Very simple. That isn't what they say. What they say, I'll just finish this. I won't take your lordships to all the authorities, because I know your lordship knows them, and you set them out in writing. But if you look at what is said at paragraph 33.3, in my skeleton, the claimant's counsel accepted the claimant faced an obligation of full and frank disclosure and said, we do say this court has jurisdiction to make an order. We agree there will be an argument on this, but if we succeed in persuading the court at trial that strait is merely a way of frustrating the judgment on the basis of trusts, there should be such jurisdiction. But how does one get to that submission?
Well, we can ask Mr. Black about it.
We can now, but we can certainly ask him, because that's not what he's saying now. He's saying something very different. And all the point about full and frank disclosures, in a sense, we may not get there, because I hope Your Excellency accepts our submission on the substance of the point. The point is a good one, there's no answer to it. Can I just finish off with the 4 points that they take against us in their skeleton? Now, the first point they say in their skeleton is, our application is defective. And that is the very first point they say. And they say that it's defective because there is no evidence. Now, that is wrong on multiple levels. It is wrong, firstly, because it would make no difference to my submissions whatsoever if we had served no application at all. The burden is on the claimant to show that it is and was entitled to the order. So even if we served nothing, it would make absolutely no difference.
We're saying you no sanction.
No, not simply no sanction. I could say everything I've said to Your Excellency this morning, and everything I've said in my second argument, even if we hadn't issued an application.
So what's the purpose of Article 2.4 of the RDC?
Because there is a distinction between discharging the order and discharging the claim. The point they're taking is a technical one. I am making it very clear to Your Excellency, we are not today seeking to discharge the claim, although it follows from my submissions that the court has no jurisdiction. The claim should be dismissed on the grounds of jurisdiction and granted. But I'm not advancing that today. The only submissions I'm making are directed to the freezing order. And I would be entitled to make all of those submissions on the basis of their evidence and their application. Everything I've said I could do even if we hadn't issued an application. But secondly, it's actually factually wrong, because if you go to bundle B, page 30, you will see that we do serve evidence. This is our application. Our application notice is at page 29. And at part C, we set out the applicant wishes to rely on the following evidence in support of this application. And then we set out the evidence we rely on. In part C.
But
Now,
again, page number?
Page 30.
Behind tab 7?
I don't have tabs in my bundle, but it starts at page 29. You should have application.
Application. No,
Yes, you have that, yes. This is our application, and if you turn over the page to page 30, in part C, the section says, the applicant wishes to rely on the following evidence in support of this application. We've then set out the evidence we rely on, and over the page, there is a statement of truth. Our client believes that the facts stated in this claim form the truth. That is evidence. Now, there are 2 points, Your Excellency. One is, we don't need that, because we're perfectly entitled to seek to discharge the order on the basis of the cases it's put against us. But it's not correct to say there's no evidence. There is evidence in that. The only point, Your Excellency, they take is a technical one. If Your Excellency accepts my submissions, as I submit Your Excellency should, then the order is discharged because there's no territorial jurisdiction, there's no basis to grant the order. What they're saying is we have to come back another day to get the whole claim dismissed on the basis of the same issue, but we'll have to do that. And if that's the point they take, we will do that. The only issue we're concerned with today is the discharge and non-continuation of the freezing. So it's wrong on 2 levels. It would make no difference if we had no application at all. I could still submit everything I've submitted, but it's factually wrong because there is evidence. The important thing to appreciate, Your Excellency, is it's the claimant that has the burden of proof to show that the court has jurisdiction to make the order, and they haven't discharged that burden. The second point they say, Your Excellency, is, so that's the very first point, effectively it's a technical point about our application, and it simply doesn't work. Secondly, they say our application is premature because they intend to seek a judgment against my client in England in the near future. Now again, that is, with respect, an extraordinary point. What it shows, Your Excellency, is they don't have a present judgment against my client, and therefore there is no jurisdictional basis for granting any order. Having a future prospect of a judgment, however likely or unlikely, is entirely irrelevant. There is no jurisdiction at the ex parte stage, and there is no jurisdiction at this stage. The third point they make is this terminology point, and that's why I've dealt with that earlier. They say, in effect, that it shouldn't be a reference to territorial jurisdiction. And on that basis, neither the case which I showed, Your Excellency, or the article from the Chief Justice should have referred to territorial jurisdiction in the DIFC. But it doesn't matter whether you call it territorial, as Justice Flo calls it, all personal, all statutory. The point's the same one. And so, whatever you call it, it's neither here nor there. But the point is that you must construe the statute, and they don't bring themselves within the statute. And in their skeleton argument, they rely on several cases which show how flexible the remedy of a freezing order is. And we say that makes that point for us. That is a substantive jurisdiction. We don't deny that the freezing order is a very flexible remedy and is a very important weapon in the arsenal of the court and can be used to meet many circumstances. But that's nothing to the issue of this application. This is the stage one. Do they have jurisdiction at all? And the answer is they don't. And pointing to cases that say that the freezing order can be used in many circumstances doesn't help unless they can meet the jurisdictional threshold. The fourth point they rely on is they continue to rely on Shabra, and that is in the face of the clearest authority to the contrary. Both Belletti and Linson, which I've shown the Lordship Belletti, both of them show that there is no Shabra jurisdiction unless there is territorial jurisdiction. I'd just like to finish with 2 points, Your Excellency. One is a case, one of the cases which I handed up to Your Excellency, which is called capital expansion.
Could you just give me a second,
Sure.
please? Yes, you may continue.
Yes, before I do that, can I just go back to corrupt Mr. Shivji asked me to make a very good point to Your Excellency. I know you will have it in mind, but if you just go back to tab 3 of our bundle. Paragraph 26.
Is this the transcript or what is it?
No, 26 of the judgment, tab 3 of that authorities bundle.
Oh, authority bundle.
Yes.
Karafi case?
Yes, in
Right.
Paragraph 26, which is page 7. Just to remind Your Excellency what the allegation was in that case.
Paragraph 20?
26. That's the bottom of page 7.
Right. Go on.
Yes, 26.
I mean, I see.
And if you just look at 26, what is said there is the nature of the allegation that was being made. It is then pleaded that in dealing with the claimant, Saracen Dubai, and or Mr. Walia and or Mr. Kerry acted as agents.
Well, I just read that.
Oh, you read it? I'm sorry.
I was reading that.
Oh, okay. Very.
Yes.
Oh, well,
What yeah.
that just simply puts the conclusion in context. The one that I showed you earlier, paragraphs 18 to 83.
It's a fraudulent.
I think the learned friend ought, before he makes that submission, to read paragraphs 74 to 76.
Right. Would Your Excellency be kind enough to read 74 to 76, because Mr. Black would like me to read that?
Well, 73, 75.
73, 75.
Because, in fact, this was the only basis upon which the court held there was jurisdiction. So, in fact, it's a point against my learned friend, not in his favour. So you may like to read that.
Well, I don't think it is against me when you look at 80 to 82, because they conclude you've got to look at it on a party-by-party basis, and that is why that is the principle I derive from this case. So I can't see that it could be against me, but Mr. Black would like you to read 73 to 75.
Right, and then what?
Well, I'll let Mr. Black make whatever he wants to. I rely on that case as authority for the proposition that you look at it on a defendant-by-defendant basis, and having jurisdiction against one defendant does not give you jurisdiction against another. But I'll let Mr. Black explain what he gets from that.
Well, I think Mr. Black, what he wants to say, and he can correct me if I'm wrong, in paragraph 26, the judge is referring to the party submission, where in 73, that is his finding, and this is the basis in which he made the jurisdictional link. Is that right, Mr. Black?
It is, but I won't interrupt my learned friend further.
Well, I'll just remind Your Excellency of 82, which is the point that I rely on the case,
Yeah.
which is a different proposition, which is that it's insufficient to rely on the fact that a different party to that against which the claim in question is brought happens to be a party to the proceedings. In other words, in this court, one looks at each defendant separately to see whether there is statutory jurisdiction against that defendant. And it's no answer for the claimant to say, I have jurisdiction against the first defendant, and therefore I have jurisdiction against the second defendant. Each must be taken separately. I'd just like to address Your Lordship on 3 further points. The first one is a case called Capital Expansion, which should be in the 3 authorities which we handed up this morning.
Yes.
And do you have it? You should see it's a judgment of Mr. Justice Millett.
Where is that?
It should be handed up with, it came with the article in the Peter Gray case, another case with it.
Yes.
And if you go to page 3 of the judgment, if you see the first full paragraph, the second line down, it says capex applied to the Queen's Bench of this court on the 23rd of July and obtained ex parte an injunction, which restrained Garmelstadt from appointing...
You said the first paragraph?
The first full paragraph on page 3.
Which reads in July 1992?
Yes, in July 1992. If you go to the next sentence,
Yep.
capex applied, do you see that?
Yes.
I only want to show you this really for the date and what happened. So capex applied to the Queen's Bench division of the school on the 23rd of July and obtained ex parte an injunction which restrained Garmelstadt from appointing or attempting to appoint a receiver or from taking any steps to enforce its security. And the order was expressed to continue until further order. Garmelstadt was given liberty to apply to vary or discharge the order on giving 48 hours notice of their intention to do so. The important thing there, Your Excellency, is just to know that the application was made on the 23rd of July, it was ex parte. If you go down to the penultimate paragraph, which begins, however,
Right.
however that may be, what happened reflects no credit on our system of administration of justice. As I have said, the order restraining the appointment of proceedings or other steps to enforce Garmelstadt's security was granted until further order. Garmelstadt was given liberty to apply to the court on 48 hours notice to vary or discharge the order. It wished to do so. It prepared evidence to meet the allegations made by capex. It has been able to obtain a hearing date before November, and then only on the basis that the hearing will take no more than a single day. If it will take 2 days or more, the application cannot be heard until January. The grant of an interlocutory injunction depends on the balance of convenience, and what is sought is an injunction restraining the enforcement of security. The balance of convenience is much affected by the length of time during which the injunction is likely to remain enforced. It is one thing to restrain a secure creditor from taking steps to enforce its security for a week, quite another to restrain it from enforcing its security for 4 to 6 months. And then he says, in my judgment, where an ex parte injunction is granted until further order, and the respondent is given liberty to apply to vary or discharge it on 48 hours notice or less, then there is an obligation on the court which granted the order to make arrangements for a hearing date with the same degree of urgency that it observed when granting the injunction in the first place. Now that, Your Excellency, is very important. The reason I draw that to Your Excellency's attention is one of the things that we submit should not happen in this case is that Your Excellency should reserve judgment until after the 21st of March, when they go and obtain judgment in court. That would be a denial of justice. Now, what happened in this case was when they came before, I think on the 8th, they wanted an urgent relief and ordered that day for the ex parte injunction. And similarly, what we submit to Your Excellency is it would be quite wrong to reserve judgment in this case until after the 21st of March, so that they then come back to court and say they have a judgment. That would be effectively a justice denied for my clients. And what we would say to Your Lordship, what we submit to Your Lordship is the appropriate course, even if Your Excellency is under pressure to produce other judgments, is that Your Excellency should give the result with reasons to follow. I'm not saying necessarily today, but certainly within a very short term. And therefore we should know the result. Because in my submission it would be justice denied to simply reserve judgment until after the 21st of March.
Well, in that case, there is an urgency for appointment of receiver. Is that right?
Yes.
And what is your urgency in this case?
The urgency in this case is that we should, if we're right, the court should never have granted the ex parte order. And the court didn't have jurisdiction. So in other words, if Your Excellency is with us, then the injunction should be discharged as a matter of principle. And no freezing order, no order should be granted against the party against whom there is a jurisdiction. It's not a question of urgency. If that were the test, it could stay in place for years until we.
No, I just thought that judgment is about matter for urgency.
No, it isn't. It goes beyond that, Your Excellency.
It's a general principle.
It's a general principle, which is if a party, a claimant, comes to court and says we need urgent relief ex parte, and the court grants that, the court needs to take, in all cases of ex parte relief, a similar approach.
So you're saying you're entitled to a similar speed of relief? Right?
Yes, absolutely. and we do submit actually more clearly, which is what obviously the claimant would hope for, is no decision until at least the 22nd of March. And then when we come back before court, they say, well, we now have a judgment. And that would be, in my submission, quite wrong, as a matter of
That's it.
Then I was going to take Your Excellency to the execution letter, which is in Bundle B at page 91. Do you see that?
Yeah, the translated one? Yes.
Yes, the translated one.
Yeah.
So what Your Excellency will see there is it's headed Letter of Execution of a Provisional Order. And then it's the respondent, refers to the case of the applicant, the wife, the respondent is the husband of my clients. Upon the request of the applicant, subject to Article 7.2 of Law 12 of 2004, we send the provisional order dated the 8th of February in the summary case, entered with the Court of First Instance on the 7th of February, and is copy translated into Arabic with the execution deed for the enforcement according to your applicable procedures. Now, we say there are a number of problems with that letter. Firstly, there is no judgment against the husband. Sorry, there's no judgment against my client. There is only a judgment against the husband, and yet the letter is addressed to both. Secondly, under Article 7.2 of the Judicial Authority Law, it needs to be a final order, not a provisional order. And thirdly, there is no ratified judgment from the DIFC of any claim against either the husband or my client.
What I can see there, just give me a second. But there is no mention of a judgment or anything in here, yeah? Right?
Yeah.
There is no mention of judgment. Or fine.
Can I just remind you, actually, can you keep that open and just go back to the Judicial Authority Law, which is in tab 14 of the claimants of authorities of the ex parte. One of the buttons I think we handed up earlier.
Well, no, just tell me what's the point you're trying to argue? Like this order is issued in the wrong form, or
Well, there are a number of points. Firstly,
yeah, you just tell me what's the argument first, and then
let me just show you what the Judicial Authority Law says, so that you can see what the powers are.
So you see the requirements.
Yes.
You want to go Article 7 or what?
7.2, yes. 7.2a. Sorry, that's page 676.
So 7.2.
Article 7.2, page 676.
Yeah, I'm in there.
So if you see, where the subject matter of execution is situated outside the DFC, the judgments, decisions or orders rendered by the courts, ratified by the courts, shall be executed by the competent entity having jurisdiction outside the DIFC in accordance with the procedure and rules adopted by such entities in this regard. Such execution shall be subject to the following conditions: the judgment, decision, order or ratified award to be executed is final and executable. So the only thing that could be done is to execute the judgment of the English court against the husband. The first point is you cannot execute against my clients because they're not subject to the judgment. Secondly,
Oh, you saying so I should not execute my own judgment or decision, or I just need to execute the English judgment. That is your argument. Because there will be two things now. There is the English judgment,
yes.
then there is a process of ratification or another
Yes.
attached application to this, and then there are going to be order of this court.
Yeah. But yes, but let me make. There are three different points.
Go ahead.
It has to be. Firstly, it has to be a judgment against my client. That's the first point. The English judgment has to be against mine. You have to find that it's contrary to my submissions.
Well, I see.
So that's the first point. Second point is it has to be final and executory. And the freezing order is not final and executory.
So it's not against your client, it's not final
And it's not final.
against your client, because there is no judgment against your client
Yes,
anyway.
Exactly. So it's not against my client, it's not final, and as far as we understand it, hasn't yet been ratified. Those are the three essential points. And then all of them are faithful.
This is new argument, it's not in your submission.
I think it is in my submissions.
Sure.
Is in Oh yes, sorry. It's in. It's true. It's in very brief form. But if you look at paragraph 35,
35.
we say the court is requested to refuse to continue the injunction and to discharge it and revoke the execution letter of the 12th of February, which is based on the freezing.
Well, you might be required to do more disclosure.
No, that's true. It's in very short form, but we do ask for that.
So you said 34 or 35?
35.
35. And conclusion?
Yes, under the conclusion. And also, I should also show Your Excellency paragraph 7. We say at the end of paragraph 7, while, sorry, I'll just go through this.
Are you saying it's implied? There's
No,
a difference.
if you look at 7, what we say, whilst the freezing injunction is persona non nature and only prevents the dissipation of assets by the subject rather than the movement of its assets, the claimant has properly used the freezing injunction to execute against the lien in the Dubai courts and obtain an arrest of the rest. So we make it clear that's what they've done with Your Excellency's order. And for all the reasons I've given, that is not a permissible approach.
I just still think it's different things.
No, I understand. Your Excellency is right. I can't say that it was
Well, I'm very grateful you understand.
but it wasn't fully expressed in the skeleton, but those 3 points are very clear on the face. And remember, Your Excellency, it's for the claimant whose burden is to show that the order should be continued. So they do need to deal with those points. One final point I should make to Your Excellency, which is this, which is they do say, or they say in writing anyway, that we can't come back and make any other points after today. Now, we have made it very clear that we are very concerned to avoid any suggestion that we have submitted to the jurisdiction. And we've raised that point repeatedly in correspondence and in our submissions, and I've repeated it today. They have never said that they are not taking any point on submission or won't take any point on submission. Now, in those circumstances, it is very normal and natural to take jurisdiction as a preliminary issue. And it is it's a perfectly efficient way of dealing with this, to deal with jurisdiction first. And I should tell you, Your Excellency, that the court often separates out the issues on a return date, and it does deal with issues which are threshold issues at the initial return date and give directions for other matters which require evidence. And just to show Your Excellency why I say that, it's not just me saying it. If you go, and this wasn't the purpose for which we put the case in our bundle, but if you go to tab 12...
Will you be finishing with the 10-15?
Yes, I'll be finishing. Sure? I'll be finishing probably in 2 minutes.
Oh,
I just want to show Your Excellency this one case and how it was dealt with by the judge, and that's it. And then I'm done. If you go to the Linson case in tab 12, and remember, I've cited this case to Your Excellency because it deals with the shadow element. But just so Your Excellency sees what happened in this case, I really want to show you the first couple of paragraphs, 1 to 4. The claimants, just Your Excellency have it, it's just this first page.
Is it this Flock's judgment?
Yes, Mr. Justice flows. The claimant applied at the return date of the 5th of July to continue the worldwide freezing order granted against the 3rd to 13th offenders on an ex parte basis on the 9th of June. Any such continuation was assisted by the 3rd to 10th and 13th defendants and so on. At the outset of the hearing on the 5th and 6th of July, it became clear that the Byrne defendants, in particular, had a number of challenges, both to the freezing injunction, no good arguable case, and failure to give full and frank disclosure, to joinder to the proceedings, no good arguable case, and to permission to serve the claim for marital jurisdiction, also granted by the learned judge on the 9th of June. No good arguable case in England not appropriate for. However, none of the 3rd to 13th defendants had filed any evidence in support of such applications, and other materials had been served late, so that Mr. Howard for the claimants was not in a position to deal with all the matters, nor would a 2-day hearing have been sufficient. It was agreed between counsel that rather than adjourn the case, I should hear the parties' submissions on the issue, whether for the purpose of continuing the freezing injunction beyond the return date, the claimants had shown a sufficiently arguable case against the 3rd to 15th defendants. So in other words, what happened in that case was, as often happens on the first return date, the defendant hasn't had enough time to serve its evidence on all the points. Happened in this case. But what the judge said is, he didn't say, well, you must bring everything together.
Well, it said arguable case.
He dealt
judgment.
He dealt with the arguable case, even without evidence. In other words, a threshold issue. No different to dealing with jurisdiction today and reserving other matters to another day. And that's exactly what happened in this case. It frequently happens. If the court can deal with threshold issues like jurisdiction, it does so. And it doesn't need evidence. For that, for example, for good arguable case, it's for the claimant to show it has a good arguable case in that case. Similarly, in these proceedings, the claimant must show it has territorial or personal jurisdiction over my clients. And it's its burden to do that. For all the reasons I've given, it cannot establish that. So, Your Excellency, that was all I was going to say in relation to the continuation of the freezing order, unless you had any questions.
Well, I'm fine. I can see sort of difficulties with this point. And you tell me if we can discuss this without evidence in place that D1 is not D2 at all, or it's not a mask for it. Mr. Black saying that I'm bringing this case because D1 is just mirror mask for D2, so actually it's D1 is D2. So if D1 is D2, D1 fall under the jurisdiction of this court. If 2 is 1, that means automatically 2 is 1, and they both fall in under jurisdiction. You can say no jurisdiction without addressing the relation between D1 and D2. Yes.
I understand your Lordship's point, and I'm glad you've raised that, because if it troubles Your Excellency, I want to make sure you understand what our position on that is.
This is one of the troubles.
Yeah. Yes. If it troubles you, I definitely want to deal with it.
Yes.
You're absolutely right. That's what he says, time and again. My client is the husband is the client. Now, the important thing to understand about that is, it is a claim. Remember, the only basis on which he's bringing a claim in this court is on the basis of the English judgment. So, the only question...
It's a claim, it's enforcement, it's dissipation,
Yes.
it's something else.
But he's not bringing a claim.
Right.
He's not bringing a claim in this court unless he can... The only basis on which he brings a claim is the judgment. Now, the point for Your Excellency to appreciate is that the judgment is only against the husband. Now, if you're with me on that, that's the end of it. The fact that he has a claim means that he needs to persuade the English court on the 21st of March
Or Liechtenstein court.
that he can, the English court, that he can get a judgment in his favour. He doesn't have that now. And Your Excellency is right. He does say this, and there's no evidence. And Your Excellency can't resolve that. But that is not the basis on which he brings his proceedings here. He brings his proceedings here solely on the basis of the English judgment. Now, he doesn't have a judgment against my clients. That, in my submission, is very clear, which is why he wants a judgment in the future, on the 21st of March. The fact that he says, I assert a claim, is neither here nor there. It's irrelevant to this jurisdiction, because what he needs is a judgment against my client. And that he's getting in the future. He doesn't have a judgment now. And that evidence, that dispute, is one that will be resolved by the English court, he hopes, on the 21st of March. And then he'll come and say, I've got a judgment. But the fact that he says, oh, the court should treat them as one and the same, doesn't give him territorial jurisdiction, because he bases his case on the judgment.
So it's not enough for him to say there is a good arguable case. Defendant 1 is defendant 2. Mr. Judge, please freeze this assets until I go back to the court of the merit and to find out D1 is D2 and the asset of D2 is asset and D1 and enforceable in their favor.
No, absolutely not. Because remember, the only basis... So can I just take Your Excellency back to their bundle, their authorities bundle, at tab 14.
Big
which is
number.
the judicial authority law. And this is very important, again, to come back to this, which is the only head of claim is the final one, E. It's not any of Article 5.1a to D.
What page?
So it's page 674. So if you look at 674, remember that none of A to D are an issue.
Right.
So if you look at, for example, B, now remember B is not relied on in this case.
Right.
But in another case, you might have a civil or commercial claim arising out of or relating to a contract, partly or wholly performed or concluded with the IOC. Now, if you had a claim of that nature, then you would get into the good arguable case territory. Is it a claim arising out of or relating to a contract, wholly or partly performed within the IOC? And that's when it might arise, Your Excellency's question, is there a good arguable case? If it was argued that it fell within B, for example, or C, for that matter. But that's not this case. This case is only E, and only on the basis of a foreign judgment. So the fact that there is a claim is neither here nor there. It's only the judgment. There is no presence judgment against my clients. And that is the very simple and straightforward point. Unless there is a judgment against my clients, that's the end of it. They don't get to the stage 1 analysis. So we're not even in good arguable case territory. And effectively, it's implicit in their case that they have to accept that, because that's why they told the court that apparently our application is premature, because they will get a judgment, they say, on the 21st of March. But it's obvious from that they don't have one now. So we simply don't get into that debate. We're not into the argument case at all. Only into whether they have a judgment against them or not. And if Your Excellency accepts that, that is the end of the matter.
Your submission is clear.
Thank you very much.
Thank you very much. Mr. Black, you prefer to go for a break? Or you would need a similar time, perhaps, is that right?
I'd be about the same length of time as my
yeah.
friend.
That would suggest that we have a break, maybe?
I'm totally...
we can make it lunch break?
Yes, I'm totally in my Lord, Your Excellency's hands, whether you want to start now or I'll start after the break. It's entirely at your disposal.
Yeah, I think it's good for everyone if we come back 1:30.
Of course.
We'll hear from you then.
Thank you.
Thank you very much.
All right.
Yeah, Michael was good. Well, I don't know.